So, welcome everyone to this webinar today, where I'm joined by my colleagues Bradley Needham and Peter Lennon, and who both specialise in providing advice to construction professionals and insurers. And I'm your host, Dan Korcz. So just a couple of points of housekeeping. Please note this session is being recorded, and whilst you can see us, we cannot see you. If you've got any questions, just drop us a line after the session and we can pick it up with you. It is nearly Christmas, so inevitably a great time to be watching Christmas films, especially Die Hard. But we're going to try and stay on task here as much as possible. So we're going to focus in this session on two recent case decisions which impact on both the construction and insurance industries. Bradley will be looking at the Smokehouse decision, which concerned an application for a remediation order for the removal of cladding and associated remedial works. The case in particular concerned arguments over the height of the building. Peter is then going to look at the recent decision in Reedweg and HCC, and which concerned claims for contribution. Before that, though, I'm going to cover a bit of the background to higher risk buildings, as this is relevant in the context of the Smokehouse decision. And it also, though, has potentially wider implications for those watching this webinar. So, just to sort of give a summary, Section 65 of the Building Safety Act introduced the concept of high-risk buildings, which I'm just going to call HRBs in this session. Those are defined as being at least 18 metres in height or having 7 stories and containing 2 residential units. So last year, the government issued guidance on the criteria for what is a HRB. So this helps, among other things, to calculate the height of a building. I've put a link to the guidance on the slide, but essentially there's 3 criteria to consider: the use, the legal definition of the building, and the height and stories. So I'm going to briefly touch on these in a bit more detail individually. So firstly, the use. If a structure's got 2 residential units and it meets the other criteria, then it's a HRB. Save for some exclusions like care homes and hospitals and a couple of others I've put on the slide. So this could in theory include a shopping centre that's got 2 residential units, but sadly not the Nakatomi Plaza because that had no residential accommodation. The point though is that the HRB is not just limited to large residential tower blocks. So looking then at the building criteria, perhaps I think quite obviously, single structures which aren't attached to other structures are buildings. Well, there might be more complex structures, I think, though, so the definitions allow parts of an overall development to be considered as an independent building for the purpose of a HRB. But to be independent, it must have, 1, its own entrance and exit, accessible from anywhere in that development, and either no access to any other building within development, or only access to another section which doesn't have a residential unit. So basically, if 2 buildings are connected with residential access, they're 1 building for the purpose of the regime. So again, point to think about here is that developments of multiple tower blocks, not all of them may be subject to the HRB regime. Finally, the third criteria, height. So the threshold of 7 stories should be counted from the story at ground level to the top story. The 18-metre height threshold should be measured from the ground level to the top of the floor surface of the top story of the building. So it sounds slightly complicated, so I've put a worked example on the slide. That's taken from the government guidance, and if you look through that link, which we had on the earlier slide, there's quite a few more worked examples. So why is this also quite critical, and particularly from a claims and insurance perspective? So if a building is a HRB, then this quite significantly impacts the progression of the works through the life cycle of a project. So some of the additional requirements for HRBs that a party concerned must look at include applying for and being granted building control approval before starting the work, notifying the regulator once building control approval has been granted, maintaining detailed record of any changes or to plans or work and notifying the regulator of those changes. There's what's called a golden thread of electronic data that's got to be maintained. There's compliance with mandatory occurrence reporting in terms of safety issues. And also you have to apply to the regulator for a completion certificate, and that could take up to 8 weeks. So we can see a sort of a number of potential impacts here on claims for those involved with HRBs. So firstly, there's an increased risk of a delay to a project where all of these additional steps have to be complied with. And particularly because it's a new regime, there's going to be very little experience across the board in complying with them. Are we likely to see an increase in delay-based claims? Possibly. And also from a professional indemnity perspective, you can see if a scenario whereby a designer cannot get their drawings approved by building control because they're not sufficient. That leads to a delay in approval and a delay to the overall commencement of the project. Also think about here that parties may be reluctant to take on construction work associated with HRBs and to be sort of the first in line in implementing this regime. That's quite a problem for buildings involving remedial schemes and where you can't find a remedial works contractor. So think about then claims coming down the contractual chain. That could increase focus on claims for interest, where you've got long periods of delay with the remedial works being carried out, and it probably also increases the focus on limitation type arguments. Where you do find a remedial works contractor, they might be charging a premium to do that work because they're so busy. And that might mean additional scrutiny is warranted for defendants where they're facing such claims. So normally it's not always that cost effective to involve a quantity surveyor to scrutinise claims for remedial works. But if you're particularly concerned about inflated remedial costs where there might be increased profit, perhaps something to think about here. So I appreciate that's a bit of a whistle-stop tour through HRBs, but if you want more information on this topic, do just have a look at our construction blog. Just a further point here as well, the definition of high-risk buildings might be extended in the future. So in the explanatory notes to the legislation, one of the scenarios it mentioned was including single-storey premises in flood risk areas. So I think that's much wider scope than sort of fire safety issues on large tower blocks. So don't just sort of think about HRBs as being limited to those sort of areas. So over to Bradley now. Can you talk us through that smokehouse decision then?
Thanks, Dan, and good morning, everyone. So in brief, I'm going to look at another building safety matter, but unfortunately we don't have John McClane to save us this festive period. Anyway, this case concerned a first-tier tribunal claim by the leaseholders of Smokehouse in East London, who brought an application against the freehold owners in November 2023 for a remediation order, or RO, under Section 123 of the Building Safety Act. The buildings were constructed in 2018 by H Construction Limited and comprise 45 flats built over a number of stories, an issue which will be important later on. They were designed with an open central courtyard, which itself was cladded, a number of balconies on the properties, and a roof garden. There were two purposes of the application. Firstly, to obtain an RO for those elements of the building which represented a fire safety risk, and secondly, to obtain disclosure and information regarding the fire safety assessment carried out by the freeholder. The applicants, led by Mr. Bromfield, said that the flats in the buildings were difficult to sell and mortgage due to these fire safety issues, and from the outset, the respondent didn't contest the making of a remediation order.
Okay, so pretty straightforward then so far. What about what happened next?
So fast forward to 2024, and by the time of the first hearing on the 27th of March, the respondent had done three main things. Firstly, they commissioned two reports on the building, a fire safety report and also a fire risk appraisal report. Secondly, it had produced a draft RO and invited the tribunal to approve it. And that order provided for, amongst other things, replacement of the courtyard cladding, installing cavity fire barriers, and also a specification for the remedial works. Now, that specification had been put out to tender, and one of the companies which had tendered for and was recommended to do the work was H, who originally constructed the building. Now, broadly speaking, the applicants agreed with many of the draft provisions of the RO, but they did want some changes, not least for H not to do the works. And thirdly, some fire safety work relating to the risers had already been carried out. Now, the first hearing on the 27th of March was meant to be listed for one day without an inspection of the property. However, like the monkey in the wrench, the tribunal didn't rubber stamp the respondent's draft RO.
Oh dear. So can you talk us through what happened after that then?
Instead, the tribunal raised concerns with some parts of the fire safety report which had been provided. Their three main concerns were that the building might be a HRB, as it could be in excess of 18 metres tall, and the report didn't mention this at all. The proposed remedial works didn't include anything to do with the roof terrace or the balconies, and it wasn't also clear what account had been given to the fire safety risk posed by the bin store and the flat entrance doors to the smokehouse building itself. So, as a result, the tribunal considered that as a matter of fairness, the authors of the reports should have the opportunity to consider the tribunal's concerns and give their responses orally at another hearing. So the hearing was adjourned as part heard, with directions given that a further fire safety report was required to be sent to the applicants and the tribunal in advance of the next hearing.
Okay, so potentially kicked a bit into the long grass then. So what happened after the adjournment?
So the tribunal inspected the building on the 18th of June 2024, and after that inspection and considering the expert reports obtained by the respondents, which dealt with the height of the building and the remediation issues, in addition to hearing evidence from the experts, the tribunal told the parties to come back to London and get together to hear it discuss the views on the key issues in the case, which were whether an RO should be made, whether the building was a HRB, and what remediation work was required. Now, the first issue was straightforward to answer. Yes, an RO was needed. And following the June inspection, the tribunal deemed that there was a clear and substantial safety risk as the building currently stands, which needed to be remediated as a matter of urgency. The two other issues were, as the tribunal aptly put, unfortunately not straightforward, even after a consideration of the relevant law and guidance.
Okay, thank you, Bradley. So we've talked a little bit so far about the definition of a HRB. What was the particular problem then in this case?
So, alongside the definition of the HRB, the tribunal also looked at the Building Safety Act's accompanying regulations about what they said defined a storey. Unfortunately, the regulations didn't define at all what a storey was. Instead, they only said what a storey wasn't to be classed as. So, by implication, this would mean that a usable rooftop containing a roof garden, together with plant and machinery, would count as a storey. However, government guidance issued on the 21st of June 2023 stated that a storey must be fully enclosed to be considered a storey. So, as the tribunal said, the government's own guidance contradicted the statutory provisions and the secondary legislation of the Building Safety Act.
Okay, so not entirely clear then if you're going to include a roof garden or not. What was the ultimate decision?
So, in this case, Smokehouse had a ground floor commercial space, 5 residential stories, and the roof terrace. So, the question was, did the roof terrace count as a storey? The applicant said it should, so Smokehouse would be a HRB. The respondent said it shouldn't. In reaching its decision and agreeing with the applicants, the tribunal relied upon the secondary legislation. And the key point that the tribunal made was when defining what a storey was for fire safety purposes, you need to look at where people might be in the event of a fire. Now, clearly, people could be located in their flats or in the enclosed stories, but where there was a roof garden, in theory, people could also be located there too. So if you think about it this way, Mr. McLean was in fact jumping off the 35th story of Nakatomi Plaza all along.
Okay, so that's something that's undoubtedly going to feature in pub quizzes for years to come then. But we left the question of the remedial works. What happened there?
So the tribunal held that the respondent should remedy several components of the building, such as the balconies, the external walls, and the bin stores. Now, the works are due to be completed by September 2025, all being well. I'm going to hand you back over to Dan now, who'll speak about the tribunal's decision and what this means in practice.
Yeah, thank you, Bradley. So government guidance has been updated to say it's considering the views by the tribunal in Smokehouse that roof gardens should be classified as a storey when determining that HRB criteria. It is, I think, important to note, though, the tribunal itself acknowledged it wasn't within its jurisdiction to formally determine whether a building is a HRB or not. The guidance still states that until it says otherwise, sector and regulatory bodies, they should continue to refer to it. It is quite clear that this is a pretty rapidly continuing landscape. So it's very important to try and stay on top of all of these developments. So on to Peter now. Can you talk us through this recent decision on the contribution claims?
Yeah, of course. Thanks, Dan. So my contribution today, so to speak, is going to be a very brief look at a case from outside the construction sector, Ridweg and HCC. It's a professional negligence case involving valuers and solicitors, which our colleague Helena Solomon has written about recently. So if anyone wants any more detail than the brief run through we're going to give today, maybe check out her article. You might be wondering first why we're discussing this case on a construction webinar, but Ridweg is being touted as the first reported case on the interaction between two pieces of legislation which come up fairly regularly in construction disputes. So the first is the Civil Liability Contribution Act, which I'm just going to be calling the Contribution Act today. Contribution Act, many of you will be familiar with, allows a party to claim a contribution from any other person liable in respect to the same damage. That obviously comes up fairly commonly in multi-party construction claims, potentially where there are multiple alleged wrongdoers but no direct relationship between them. So, for example, you might get a situation where you have an architect and a building engineer who are both alleged to have contributed to defects in a building. What you may then see is, for instance, the architect being sued and bringing a Contribution Act claim for a contribution from the engineer. Second piece of legislation that's considered in Ridweg is the Third Parties Rights Against Insurers Act, which we're just going to be calling the Third Parties Act today. Now, purpose of the Third Parties Act is to allow claimants who've suffered damage from an insolvent defendant to claim directly against that defendant's insurers, if there are any. So the construction sector's obviously no stranger to insolvencies, and insurers in the sector need to be familiar with the possibility of Third Parties Act claims. The way those claims operate, which is going to be important when we get into Ridweg, is that claimant effectively steps into the shoes of the insured. So if they can prove that the insured was liable to them, and then that the insurer was liable to indemnify the insured, they can force the insurer to pay the indemnity directly to them, the claimant.
Okay, yeah, thank you, Peter. So do we actually know what happened in Ridweg?
The short answer is no. It's important to note that the facts in Ridweg are still yet to be determined by the court, because the underlying negligence case is actually yet to be decided. However, claimant Ms. Ridweg alleges that she received negligent advice from a firm of valuers called Gold Plaza. Gold Plaza have since gone insolvent, so she then brought a claim directly against their insurers, who were HCC, under the Third Parties Act. The insurers, during the course of those proceedings, applied for permission to join Ms. Ridweg's solicitors into the litigation. They alleged that they had a Part 20 claim against them, and this decision deals solely with their application for permission to bring that claim.
Okay, yeah. So what was the basis then of the claim by the insurers?
Well, fundamentally, it was an attempted Contribution Act claim. So the insurers alleged that they had a claim under the Act. To go back to the critical wording from a few slides ago, the parties have to be liable in respect of the same damage for the Contribution Act to apply. So insurers' argument was that the solicitors were liable in respect of the same damage as the valuers, Gold Plaza, which was the source of the claim but was then being brought against insurers under the Third Parties Act. So they argued they should be allowed to bring a Contribution Act claim against the solicitors.
Okay, so quite familiar, hopefully, to scenarios a lot of us tend to face. What was the decision then?
Well, the court ultimately disagreed with insurers and sided with the solicitors. And if you're seeing the chart on screen at the moment, the fact that there are two separate arrows for insurers and valuers is possibly teeing up as to why. The key point is that the Third Parties Act doesn't change the long-standing principle that insurers are not responsible for the damage caused by their insureds. So the only damage insurers could be liable for was their indemnity under the policy, not the damage caused by their insured valuers. So the court said it might well have been the case that the solicitors and the valuers were liable in respect to the same damage, but the Third Parties Act claim that was actually being brought against insurers, and insurers' potential liability was not for the same damage as potentially or allegedly caused by the solicitors. So the court concluded insurers had no claim under the Contribution Act and they refused permission for it to be brought.
So not a particularly helpful decision then for insurers. Is that the end of it? Are there things, sort of workarounds that we can consider then?
Well, the decision was in the High Court, so it has limited effect for now, but it does seem to limit the options open to insurers to recoup contributions if they're hit with Third Parties Act claims. There's a couple of potential caveats to that. So Ridweg, for various reasons, didn't have to deal with subrogation in judgment. So indemnity insurers who make a payment on a claim would be subrogated to their insureds, and they might have a right to bring a subrogated claim for contribution in separate proceedings in the insured's name. That's obviously not ideal for insurers, because separate proceedings mean insurers take on the risk of bringing those proceedings, and you're potentially going to have a pay and recoup situation where insurers have to pay out first to the claimant and then try and claw back some of that from a contributing party. However, you can see in a mediation context how the threat of bringing a subrogated claim later might be enough to get a potential contributor to the table for settlement purposes. The other option is potentially to invite the liquidators of the insured to assign the benefit of the insured's cause of action. So if the insured has a cause of action under the Contribution Act, that could be assigned to insurers, but then liquidators may insist on consideration for doing that. They might want a payment in exchange for the assignment. So obviously that's an approach that has its downsides as well. I think the final thing we just add is that this is very likely to go to appeal. The High Court recognised the importance of the decision and gave permission to appeal. So it seems fairly likely that there's going to be a sequel to this one, so to speak.
Very exciting. Well, thank you, Peter. Yeah, that's all we've got time for today. Thank you, everyone, for joining us this morning. Just, I think, a few closing thoughts to try and take away. So we anticipate there being additional scrutiny on claims involving HRBs. And there's probably going to be more delay-based claims, and that could include professional indemnity claims associated with delayed approval. So probably worth thinking about an increased use of quantity surveyors on those claims for remedial works, particularly if you think there's sort of any inflated elements. Very quickly evolving area though, so please just keep an eye out for our future updates on this topic. Also, that decision on the Contribution Act, that all potentially could make matters worse and more difficult for insurers. But I think, as Peter has explained, there are a couple of workarounds to this, so it's not the end of the matter. As ever, if there's any topics you'd like us to talk about in the future, remember, and if you want any more detailed answers to anything we've discussed today, just let us know by email and we can get in touch with you. There is a feedback form which is going to pop up at the end, so add any thoughts in there. But for the avoidance of doubt, we're not going to be debating if Die Hard is a Christmas film, as it unquestionably is. Right, our next session is on the 14th of January. A topic will be released in due course, so just keep your eyes out for that. Hopefully you can join us then, but in the meantime, have a very good rest of the day, a very happy Christmas and New Year when you get there. Okay, thanks. Bye.